I might be bloody lucky. It's
Worked before.
something to do with an classic Australian movie, isn't it? Yeah, fuck.
What section of the Constitution has been breached?
Section? What section? There is no one section. It's just the vibe. It's all part of it. This is what I'm getting at. But that's my point. It's the vibe of it. Again, it's just the vibe of it. In summing up, it's the Constitution, it's Marbo, it's justice, it's law, it's the vibe, and no, that's it, it's the vibe. I rest my case.
That was sensational.
We had a good old laugh about that, and it's interesting, that is in regard to someone sticking up for their rights and getting back the land the developer was going to take away. So that's where the storyline started from as well too, because what they have done, the Broadbeach Law Group, and I always refer business, have for a long, long time through Clinton, Brody, and principally, I thought you might be up here too, Tom. Tom should come up here too, shouldn't he?
Oh, he'd just be twiddling his thumbs, that'd be mean.
Okay, fine. Okay, fine. Okay, so therefore, people will explain what happened last. This is big because it was off the plan throughout Queensland, etc. What a lot of them have been doing, because the price has gone up so much over the last few years. The developers don't want to settle. They refuse to settle. They'll back. You'll understand that. They refuse. They'll do everything under their power not to settle, because the prices have gone up $100,000-$300,000 per property. If they have the multiplying effect for them, why would they want to settle? They don't want to settle. They want to resell them to get an extra $200,000 or $300,000 on every property. And sometimes we're only speaking about one developer. You have the multiplying effect where some people have got a truckload of developments going out of the ground, etc. That's what happened. So this is the first. You explain from a legal perspective. I've given you the introduction.
Oh, yeah.
And here's the legal perspective.
All right. All right, couple of quick corrections.
Yes.
Wasn't the Constitution, and we weren't in the High Court of Australia. Just the highest court in Queensland, nothing crazy. Now, just before I get into it too, I just want to introduce Tom, who Campbell's already pointed out. Tom's a law graduate that started with our office, a couple of months ago now? Yeah. And it would be mean to get him up here just twiddling his thumbs while I talk, so I figured he could say sitting down. But no, Tom's an exceptional law graduate, and he's getting admitted to practice on Monday, and we're all really excited about that. So you'll be seeing more of him around here, particularly since I'm taking a holiday for 4.5 weeks. All right. Well, I mean, Campbell's already given me a pretty good introduction, but the case that we've been dealing with over the last month was really a landmark case in Queensland. We're acting on behalf of 23 applicants that had 15 contracts for the off-the-plan development Vantage View in Benoa. It's, yeah, I'm sure a few people have seen it already. Now, all these contracts were signed, I'd say, in around 2021 to late 2023. And on average, people paid a deposit of about $59,000. And the property prices for those units have increased by about $300,000 each. Now, none of these contracts were subject to finance, and they didn't have that typical 14 to 21 day finance clause. Now, that's common for off-the-plan contracts, and normally the protocol is, you'll get notice for settlement, giving you about 14 days to get ready to settle, and at that point, the developer will let valuers come onto the property, do their valuation so people can get finance, and then people will pay with finance at settlement. Now, in our case, the developer called for settlement on the 1st of July, starting the 14-day timer, or really it was 14 and a half days. It was 16 July settlement was called for. Just before the 1st of July, we sent a letter saying, look, we've got 15 contracts, 23 people that need access for valuers. Without these valuers going on, they're not going to be able to get their finance, and they're not going to be able to settle. Now, we didn't hear anything until, we didn't hear anything up until the 5th of July, where we filed the application in the Supreme Court of Queensland. And then on the 8th of July, they said, okay, well, here's a regime to let your people on. So, we're okay. And then you'll have 7 days to get your valuations done, get your finance ready and be ready to settle, which isn't practical. So the hearing took place on the 11th of July before Justice Applegarth. We had Nick Ferret KC as senior counsel, who is brilliant, and Alexander Choi as his junior counsel. They were instructed by Brodie Hatswell and myself of the firm. Now, the duty, or the orders, or what the applicant's case was that the seller had, or the developer had, a duty to cooperate with the applicants, and that's an implied duty that's good law in Queensland. And the duty really requires, and I'm quoting the authoritative case here, Button McDonald, requires the parties to do all such things necessary on his part to enable the other party the benefit of the contract. Now, in the applicant's case, the benefit of the contract is being able to get the transfer of the unit from the developer to the buyer. The developer's point of contention on that was that the buyers had really set out to obtain the benefit of getting finance under their contract, and as I said, the contracts were silent as a subject to finance clause. Now, the Queensland Court of Appeal had previously considered this duty where there was a subject to finance clause, but because this is an off-the-plan contract that didn't necessarily say one way or the other, this was really uncharted territory. Now, Justice Applegarth recognised that off-the-plan contracts aren't, typical contracts, and that really you can't make an off-the-plan contract subject to finance. And I know a lot of people in the room here work in finance, and I'm sure you'll agree. You can't put a 14-day finance clause on a contract that isn't going to settle for 2 years and the building hasn't even been started yet. I mean, how is a financier going to look at a property and say, okay, I can secure a mortgage against this, when really at this point it's just a construction site, if that. And Justice Applegarth, being a man of the people, I think recognised that. And he said, in response to counsel for the developer, in the real world, most financiers wouldn't lend against blue sky or a half-built building or a property that a valuer hadn't inspected and valued. Now, notwithstanding that there was no subject to finance conditions, the applicant's or our submission was that despite that, the contract did contemplate that there could be a financier. Throughout the contract, and these off-the-plan contracts are massive, there were references to obligations of a financier if there was one at settlement. For instance, a financier can't put a caveat over the property, things of that nature. So the idea was that, okay, it's silent on a subject to finance condition, but you've considered that there could be one. So really, that implied duty to cooperate should extend to letting a valuer on to value the property so that they can get the finance. Now, thankfully, Justice Applegarth agreed with that, otherwise it would have been a really short hearing. Now, after failing at that hurdle, the developer's next argument was that, okay, well, look, we gave them the access at the 8-day mark, which between us they would not have done if we hadn't have filed. But we gave the access at the 8-day mark, so they had 7 days to get a valuer to come on site, get a valuation to their bank, for their bank to send the mortgage documents, for them to sign the mortgage documents to go back, and then for them to have the money to be ready to go. Yeah, right. And this isn't the case summary, but I know, yeah, right. I mean, sure, some financiers could do it if you have your foot squarely up their arse the entire 7 days. And this isn't in the case summary, but I like that Justice Applegarth recognised this. He said to the counsel for the developer, he said, look, so you think it would have been reasonable if you gave access for the valuers the day before settlement? And he said, yes. Yeah, look, I won't say who it is, but counsel for the other side is strictly brilliant. He's one of the top 5 in Queensland. As a result, I think he makes about $1 million a year. So he probably wasn't quite as in touch as these mum and dad buyers and small time investors were that obviously needed this finance to get it over the line. And on that point, Applegarth even said to counsel for the other side, which was probably my favourite part of the whole hearing, unless you're carrying $1 million in your knapsack, that's what you're doing during the 14-day period. So thankfully, Applegarth did determine that either by failing to give that access until after half of the notice period had been burned, or by giving the notice to settle when they couldn't give that access, the developer had breached its duty to cooperate with the buyers. And as a result of those orders, the developer was restrained from terminating any contracts that didn't settle on the original settlement date of the 16th of July. So it was a really good result, and it came with an order for costs for all the applicants. Not quite finished yet, sorry, Campbell.
Oh, no. I was clapping that for starters, and then I was going to
No. Now, we did manage to get, of those 15 contracts, all but 2 through on the 16th anyway. So happy days, the foot up the arse for the financiers worked. Now, but for the 2 that didn't settle, if they hadn't have settled on that day, I think their combined deposits were, 160,500, not to mention the 300-odd thousand each that those units were worth in addition. If we hadn't got those orders, they would have been terminated that day, would have lost the deposits and the apartments that they've been waiting years for. So we were really happy with that result, but then not being so happy, the developer decided to appeal the decision. So we ended up in the Queensland Court of Appeal on, what was it, the 25th, right? Last Thursday, yeah. So we ended up there again. Again, same counsel, same solicitors, and I won't go through the points of law on the appeal because we'd be here for an hour. But the upshot of it was that the Court of Appeal saw the developer's case and ultimately said, yeah, no, we'll dismiss your appeal and we'll award another order for costs as against you to pay the applicant's cost of this appeal. So happy days all round.
won the appeal and won the costs as well.
If we'd lost the appeal, our guys would have had to pay their costs, so
Yeah.
we were pretty happy about that. Yeah. But the reason why this case is important is because, as I mentioned earlier, it's untracked territory in Queensland, particularly for off-the-plan contracts like this. And considering it's been dealt with by the highest court in Queensland, it's likely going to stand for at least the next 20 years as authoritative law for a case where a developer wants to obstruct a buyer from accessing a property to get a valuation or for settling or obtaining finance to settle. So, ultimately, we're all really happy with the result, and hopefully it's good authoritative law that will be referred to for many years to come. And the developer that could have made a good couple of million ended up paying his legal fees and the applicant's legal fees.